Um, Talking about contracts, I wanted to give you a primer in contracts. Um, this is sort of an outline. I'm intending to do it in two parts. Um, I may or may not show you how to do a PowerPoint as we're going forth. I'm not as good as I like you to be at PowerPoint. But basically, to have a contract, most textbooks and most legal authorities are going to say you need these four elements. You have to have an offer accompanied by an acceptance. A counteroffer is not acceptance. I offer to sell you my car for $2,000. You say I'll pay $1,700. I can walk away. Um, if you said, yeah, I'll take it, boom, I've actually, we've now, well, we'll see whether we've got one, but we've at least fulfilled offer and acceptance. Consideration, something of value to each or from each, but each party is receiving something of value. One of the key elements here is that it doesn't necessarily have to be the exact value. I might offer you $1 million if you were my son, if you don't marry till you're 35 years old, because I've got an idea that boys just don't do well until they're older. You'd be giving up quite a lot, and we'll get into that. Maybe I'm just going to put that one on. But is it really worth $1 million to me to have you wait that long? I'm not real sure. So let's hold that one. Let's look at this in a little bit. The next part is legal capacity. You really have to be able to think clearly. You have to have perfect cognition? No. But minors don't have legal capacity to enter into a contract. And the last one is legality of purpose. So anyway, I may have already spoiled the what I wanted to talk about with these. But you cannot have a drug deal, for instance, be enforceable in the courts, or fraud against the government, or something like that. No, we're only going to waste our time in court enforcing valid contracts that have a legal purpose. Looks like I need to update when I did these because I just updated them, and it should show a much older. It's about 9 years later, because this is, well, it's not 9 years, 8.5 years later. Anyway, offer and acceptance is the meeting of the minds, is how this is ordinarily talked about, that the two parties agreed that basically we have a contract. This applies a little more in some of the bigger, more nebulous contracts. But do the parties generally agree that, we've agreed to sell Yahoo to Verizon? Did they come to a real understanding in this process? The interesting point here is, are we going to apply a subjective, that is, yes, I knew what I was buying, or an objective standard, a reasonable person knew what you were buying or selling? Which do you think? Well, if you look at the law, if we always apply subjective standards, everybody gets an out. Oh, I didn't really understand that. We cannot, from a third party standpoint, enforce the law if we use subjective. So walking into this, understand that you're not going to be able to go, well, I didn't really understand that. Once you've signed the documents or given your assent under ordinarily accepted standards, it's over. Other thing we're going to look at is, do you really need a formal agreement or writing? It turns out that you don't. There's a giant deal. I think it's a real outlier, but it was enforceable. There was a handshake agreement between a couple of big oil companies. I believe it was Texaco and Phillips. To sell one to the other. and it was enforceable. It was a $10 billion contract, and there was no writing. There was no reduction to writing because, it turned out, I can't remember, a day or two later, the other party got a better offer and they wanted out. And the party that really wanted to enforce it, and it may have been Pennzoil, went to court with it. And in Texas, they won. There was not a writing, but they had really agreed on the general terms. It's the only case like that I know of, but we have to understand in business, hey, this kind of thing can happen. And the big deal was that, they each ran up $10 or $15 million law fees, one side or the other. I think they ultimately settled it out of court, but it was still a pretty big loss. I don't believe it was publicly reported. I'm not certain they went through with it ultimately, but they did get a judgment that you owe us this. Anyway, on offer and acceptance, big deal can be timing. For instance, most real estate contracts, I have a written offer out there. Those have to be in writing, as we're going to see in the statute of frauds, which is the do we need a formal agreement? I'm sorry, I jumped ahead of myself. There are things in almost every state has a statute that they call the statute of frauds. Certain contracts have to be in writing to be enforceable. And you can almost see this in the like a car. There's always got to be a bill of sale that is done there. Real estate, always in writing. Contracts that take more than a year to perform. I should wait and hold this, but I used it because in real estate, we usually only give you about 72 hours to consider the offer. And it's because the person is sitting there, I'm trying to find a house. I don't want to shilly-shally around with a seller who wants to wait 2 months to make up their mind whether they take the offer. So we usually do commercially reasonable time under the UCC. And some of the UCC stuff and the UCC, Uniform Commercial Code, is the old code merchant that we found in the kind of almost in the Code of Hammurabi, and then it's just been added on to for years. But timing of revocation of offer or acceptance, if we're going to revoke an acceptance, ordinarily we've got to do this really quickly. Otherwise, the other party may have incurred damages. We can always settle it out in damages. Hey, it cost me $10,000 to do this cost estimate on, how we were going to ship this or whatever. We may, if we revoke, have to pay that, or if we're slow doing it, we may actually have an enforceable contract. The general rule in offer and acceptance is that a counteroffer violates what's called the mirror image rule, if you will, that we have to have both sides agreeing that this is what the deal is. We're selling this $2,000 car. You'll pay me $1,750. I come back at $1,900. You say done. We're now in mirror image. We both agree it's a $1,900 car. All right. And that's basically what that constitutes offer and acceptance. We both have a reasonably reliable idea of what we're doing. The UCC can have a different take on this, and I believe it's section 2-207 of the Uniform Commercial Code. It favors formation of contracts. And so it may be that if we modify the terms of the sale, that, for instance, when we looked at the car, I had my toolbox in there. Well, you may think... sorry about my interruption. My a worker came by to do some work here at the house. So I've been knocked for not being very professional. But under the UCC, we're essentially trying to make sure contracts happen. Business keeps rolling. We'll talk about this much later in the semester. I don't always appreciate the full ordering of chapters, but I think it does make sense to put the UCC later to get through all of the torts and the crimes and everything else, because those are kind of the basic understandings of the law. And as we begin to look at contracts, which is, the very foundation of business, I offer to sell you this, you buy it. The average cash register transaction is a contract. It's offer. Here's how much we put the late price on it. You bring it to the register. We scan it. You pay for it. We've got a contract. Now there may, and then of course what comes with all of this. So let me see. There we go. All right. So one of the things we got to have is exchange of consideration. Cash works, right? I have my phone. I'm tired of it. I want to sell it to you for $100. We agree it's good. Boom, boom, boom. I gave you something of value. You gave me something of value. Periodically, though, the something of value isn't apparent, all right? And I think I gave you the example of I tell my son I'll give him $1 million if he doesn't marry till he's 35. Well, first of all, I don't have the $1 million, but nice example. And I don't really care. But there are a lot of cases out there where rich uncles have said, hey, don't drink or smoke or go to brothels till you're 25 years old or whatever. And I'll give you a pretty big sum of money, or I'll pay for your college, or, I'll pay off your college debts, whatever. So why would the uncle's not getting anything? Well, that's true. And the kid's not really giving up anything. Yeah, also kind of true. But the uncle is getting something. He's getting peace of mind, all right? That, if this kid can hold that up, I've got a high likelihood that my child won't have an infectious disease, that, they won't have started down the road of alcoholism, because, a lot of studies show the first drink is all it takes for an alcoholic to become an alcoholic. Boom, it triggers everything. Immediately, and they lose control immediately too. Cigarette smoking, same deal. I mean, some people have one puff on a cigarette and they're hooked. Boom. You wouldn't think it's quite like that, or heroin, et cetera, et cetera. We could technically say that the child's not giving anything up because they don't have the right to drink till they're 21, but we all know that you can get hold of all of this stuff regardless of age anyway. So in a way, and that's why I changed the hypothetical from an earlier version of this lecture, is that up to age 25 we're going to make this happen. Well, that's 4 years where the kid could freely be drinking. He's giving up something he has a right to do. He can go drink. So even though outsiders might not value this at all, to these two, it could be valuable. Ordinarily, we're also going to have things where we have an action. I'm going to redo your bathroom for a set price. So action could be, it could even be omission, not taking an action. But ordinarily there has to be something of value. The interesting thing to me, and maybe this is legal scholar stuff, is, again, we're using this objective standard, but we here maybe look at subjectively, is it really something that somebody might value? We don't care about whether we've hit a perfect value on any contract. Everything would grind to a stop if we look for perfection. It's kind of a life of good enough, okay? And then, of course, the exchange of an item. Any item has value, even this pen. if I want to pay $1 million for it, who cares? They hand these out free at the Holiday Inn. Well, not free, but anyway, someone, maybe it was the pen in the Holiday Inn Express when Trump stayed there rarely or whatever, or Hillary Clinton was there. Or, I'm not going to go any further on the Clintons because there's an obvious Bill Clinton joke, but we won't go there. And it may be that your textbook has one. My old book did, and that's when I did these. The last part we're getting to is there there has to be a legal purpose to the contract. That's the one on the bottom. A drug deal is unenforceable. If I go to my local dealer and, he sells me a bag of oregano, I don't have any way to enforce that. Okay. That's, and I don't go to my dealer anymore. I used to, but not anymore. But I should wipe that out. I'm not going to wipe that out. I finally got past that. And, but local, whatever. The one we see the most, of course, is much more, so a mob hit is not legality of purpose. You cannot enforce that, hey, you're going to kill my wife or whatever. I can't force you to do that. The courts are not going to have any part of that because it has to be a legal purpose. The last part is capacity to contract. So some people, like someone with Alzheimer's, may or may not have capacity. Okay. And so we've got to be careful anytime we're dealing with someone like that. The elderly are that way. You'll also see below that minors are definitely that way. We do have some some impaired factors that may be only temporary, such as somebody was drunk. Now, this gets us into some interesting area, were you a little bit lit up and still able to function, or were you, are you three sheets to the wind and not able to function? Where does the line draw in? And we may bring in third parties to testify about this sort of thing. Ordinarily, if you have any suspicions about somebody as to whether they really have the competence, the problem is if you contract with somebody, someone can always walk back in later and go, you couldn't contract with them. They've been declared incompetent. And usually courts of law are the one that do that, and then they appoint somebody who is guardian either of the person or of the estate or of both. And so the way around this is we maybe make the contract with the guardian of the person. A way that I get around things like this, my mom got to be about 85 years old, very trusting, lots of people making offers to her. A lot of people prey on the elderly. And I talked her into it. I said, look, make me and my sister the trustees of the majority of your assets. And therefore, for someone to be able to get a lot of your money, they got to go through me and her. And she was a little resistant at that. She wanted to maintain it. But I said to her, it's not like we're going to cut you off. We're trying to protect you from people who prey on the elderly. And there are a lot of people who do. And, she would not, because she's a nice lady, be able to get out of some contract where she pledged off a lot of money. Maybe she wouldn't do that, but it's just a lot easier for us to go, no, you can't, if you will. So, if an elderly person in your family is amenable to that, I think some other professors have kind of taken over their dad's estate, because there were contractors who would just quote these huge sums and dad would just pay it. It was like $1,200 for a $500 repair. Well, you can go through a fair amount of money pretty quickly. So anyway, the big deal in minors is seller beware. If you contract to sell a car to a minor, and the minor gets into a terrible wreck with you, or with the vehicle, they can come back with the little cube that they can turn a car into, when they smash it, and say, here's your car back. I don't want it. And they've got the right to get out of the contract because the contract was never legal in the first place. You do not. Minors don't have the capacity to contract. And so I think one of our example cases will be you can see that the parent was a co-signer, or they failed to have the parent co-sign, or they, but there is, once the minor becomes an adult, there's an affirmation process that can take place. And if the minor doesn't move to revoke it in a reasonable period of time, say they're making car payments and it's 18 years, 3 months on, and they decide, I don't want this car anymore, they come bring it back, chances are it's now enforceable. They've already made 3 more months of payments as an adult. That transition is a hard one. And a lot of 18-year-olds aren't ready for that transition, but the law treats you as an adult. Anyway, so that's kind of the first half of this. The second half is a little more technical, a little more focused, I hope. And thanks for listening. I'm trying to keep these a little bit shorter.